Hello, good evening. I trust we are doing great. Right, welcome to this subclass for our simulation session. Please, Melody, if it's possible, please can you go ahead and let the other mentees in your subgroup know that the simulation class has started so that we can start off immediately. Okay, good evening, sir. You're welcome to today's class. Welcome, Mr. Nyacham. Also, welcome, Melody. Thank you for joining in. I don't know what seems to be the issue why our mentees are not on call yet, but we'll try and work on them, trying to get them to join the session. Okay, good evening, everyone. Thank you guys for joining. Those that are able to join in on time, you're all welcome. This is our what I call it now, our sub-session for the simulation class that we're supposed to hold last week, but we didn't. Right. I'm sure that those already on call are part of a group and they are ready for the simulation. We are supposed to start immediately, right? But I don't seem to understand why we are not yet here. So please, I want to encourage you. Mr. Nyacham has left the call, but I want to encourage you to try to still remind your friends that we're supposed to have this session by 5 o'clock so that we can start, and then our mentors can also join in and give the comments because basically we don't intend that this session is going to take too much time. Right? We just want for us to have the simulations and then feedback from our mentors, and with the feedback we also would be with the feedback you can also ask questions, and then we can have our mentors just you can have us ask questions and our mentors answer our question. So please kindly let your friends know that we're starting the session has commenced. So thank you all for joining. My name is Dennis Williams and I'll be moderating this session. So not to waste any further time, not to waste any further time, we will be introducing the mentors we are supposed to have today. Um, just like last week, the same mentors that we had last week, we expect them to be with us, to be joining us shortly for this particular simulation session. And just to forget, it's not forgetting, I want to wish everyone a happy Salah celebration. That's for the Muslim faithful among us. Just wish them a wonderful Salah celebration. Um, we we hope that the celebration of the day will be as smooth as possible, or is going as smooth as possible, and that it will bring in itself wellness, as the love and prayers, and all their prayers will eventually get answered in that sense. So, not to waste any further time, like I said, I'll just be reading or be sharing the slides on our mentor's profile. Um, we expect to have the same, like I said, we expect to have the same mentors that we did for last week, and one of the mentors we're expecting for this particular class is Mr. Nyacham now one, and the second is Mr. Samuel Orobusa Osarenre. Right, we're expecting Mr. Samuel to also join in. Thirdly is Mr. Idris Mohammed, Miss Baratu, um, okay, and Miss Mispa. Right. So please, can we just kindly exercise patience? Well, let me try and see if I can get through to Mr. Nyacham to see him if he can join back into the session. Okay. I think it's fair enough for us to start off with the simulation if that will be possible. Right. I'm sure since um the session is being live streamed, our mentors can always go back to visit the video. So please, I would like to ask that um, please we can just kindly go ahead and off with the simulation, not just so that we don't waste any further time. Right? We are supposed to have two groups. We are supposed to have two groups participate in the simulation. So group one, if you're ready, I'm sure you people have done what is needed of you to do. Right? If we have members for group one that are prepared for the simulation, please you can turn on your video and then you can go ahead and start. So please, can we have our mentees turn on their video camera, unmute themselves, and then go ahead and start the simulation. Group one, please, you can go ahead and start. Welcome, Miss Mispa. Thank you for joining us, ma. Group one, please, are you ready? Are you ready for the simulation? Please, we are good to go. Please go ahead and start. Group one. Hello, please. Can someone confirm that they can hear me?
Sure, I can hear you.
All right. So please, group one. I'm sure you are with us. Please go ahead yourself and so that we can start the simulation as soon as possible.
Good evening, sir.
Yes. Good evening, Mr. Augustine.
I'm trying to get the people who are supposed to present for the simulation. I'm trying to get them to come online. I'm calling all of them. I don't know
All right.
why they are online. Even the presenters of the weekly article, still calling them to come online. I'm texting them in the group right now. So in a few minutes time, all of them will be here, sir.
All right. Thank you, Augustine, for clearing that up. So please, since we don't have the complete number of people who are supposed to take in the simulation for group one yet on call, please, if group two is ready, can they start? Okay, can we have group two if you are ready? If those who are supposed to participate in the simulation for group two are ready, please can we go ahead and start? Okay, Melody, please, you're muted.
Good evening, sir.
Yes, good
Can you hear
evening,
me
ma'am.
now?
Yes, I can hear you.
I'm sorry, unfortunately, all the people who are supposed to participate in the simulation are not here now. So I'll quickly try to
I'm
reach out
on
to
the
them.
call.
Sorry.
I'm on the
You are
call.
here?
I just called Ephraim now. He's coming
Okay.
online in a few minutes.
Okay. So we'll be ready in a few minutes, sir.
I
All
called
right.
Ephraim just not too long.
All right. So please, let's try and see if we can get them on the session on the call as soon as possible, so that we can start and not waste any time. We already have two of our mentors on the call. Thank you, sir and Ma, for joining in. Sorry about the delay from our end. We hope that our mentees will be able to make their simulation as soon as possible. So please, group two, please, if you people are all complete right now, you people can start.
Hello, Mr. Ephraim. I can see that you're on the call. I think we should start now. Mr. Ephraim,
Oh, okay, Melody, please can you just go ahead and introduce who the arbitrators and the parties will be, so that while we wait for him to while we wait for him to unmute, or for him to join his audio, we can know who are the parties that are involved, and we can start with the and listen once he's able to join in. So please, you can go ahead and introduce the arbitrator, who are the parties involved, and who are the people that will be representing the parties.
Okay, sir. So for this session, we we are going to be three persons representing group two for this simulation because, well, most people didn't show much interest. But for the course of this session, Mr. Ephraim will be taking the role of the arbitrator. You'll be standing as a sole arbitrator over the matter. And then I personally, Melody, I'll be representing the company in this simulation. And then with me is Favor, who will be representing the complainant, Mr. Musa, in this simulation. So we're just waiting for Ephraim because we're supposed to start the session as we rehearse. So he's going to come up and take his role, and then we'll follow through.
All right, thank you very much for introducing the parties and the roles they'll be taking. So, Mr. Ephraim, if you're with us, you are the arbitrator for you are the arbitrator for Group One. Please, you can go ahead and introduce the simulation for Group Two. I mean, Group Two. You can go ahead and introduce the simulation for your group and carry on with the rest of the simulation.
All right, so sorry to join late. I'm so sorry, sir.
Program,
Can you
please.
hear me?
Yes, yes, we can hear you. If it's possible, we'd like to for you to turn on your video.
Your video, okay.
All right, please, you can go ahead and start.
Okay. Good evening. My name is Ephraim Azaria. I'm appointed to serve as an arbitrator in this matter. Before we begin properly, I would like the parties represented here by their representative to introduce themselves before we commence.
good evening, everyone.
Good evening.
My name is Favor Okoye, and I am representing. Is there anyone hear me?
Please, can you come
Favor,
close?
your network is cracking, so please, yes, can you hear us now? Your network is breaking.
I can hear you. Good evening, everyone. I'm Favor Ogozi, and I'm representing Musa in this arbitration session.
Okay. The next one, please.
Good evening, everyone. I am Miss Melody Ogenetega. I'll be representing A and B Company, the respondent in this matter.
Okay. All right, you are all welcome. As you know, arbitration process is a process for resolving disputes outside the courtroom, which is governed by the Arbitration and Conciliation Act 2003. In this matter, we are going to hear evidence and arguments from both sides, and I will make a final binding decision based on the facts presented before me. So I would like to stress that my role as an arbitrator is to remain neutral and impartial throughout the proceeding. I have no personal or financial interest in the outcome of this case, and my objective is to ensure a fair and efficient resolution of the dispute. I want to emphasize that any questions you have, you can raise it here now before we start. In the absence of any, I would like the claimant to state her claim before we.
Okay, thank you so much. I am here representing Mr. Musa, who is the complainant in this issue, who is the claimant in this arbitration session. Well, the fact before me, and according to everything that my client has stated, is that A and B Company here employed my client, and after due documentation was done by him in his company, there was a lockdown directive by the Kaduna State government. And due to that fact, he inquired from this company, that's the A and B Company, how to go about his work and how he was going to be productive during those stages of lockdown. The company therefore replied him stating that the HR personnel, that's the human resource personnel, was going to send him a message on how was the modalities of his work. Well, this complaint is due to the fact that for after 8 months, Mr. Musa, who is my client, did not receive any instruction, any message or whatsoever from the A and B Company, and he has suffered lots of damages due to the fact that he couldn't fend for his family, and he had resigned from his previous employment just because he had gained employment with A and B Company. And this is the reason why he's bringing this matter before this session, so that A and B Company can rightfully compensate him for the damages that he has passed through. Thank you.
Okay. The respondent, Mrs. Melody, please, can you say something?
Thank you very much. As rightly stated by the claimant, my client A and B Company offered by the claimant's representative here. My client A and B Company offered the claimant an employment on the month of March 2020 to the effect that he was to resume duty on the 1st of April 2020. However, due to conditions beyond the company, as a lockdown was stated to occur for the period, Mr. Musa, as well as other employees, were unable to resume duty fully at the office. However, provisions were made for the period for these employees to work from home. And to this effect, the human resource personnel was duly instructed by the company to send emails to all the employees as to how they are going to be carrying out their duties online from their various homes. And as a matter of fact, on the 3rd of April 2020, human resource personnel turned in a document to the effect that those emails have been duly sent to all the employees of the company. And we've been working with that record since then. However, it is to our dismay to get this, to our utmost dismay to get this petition against us that the said Mr. Musa was not giving any email to this effect, as emails has been sent before now to all the employees. However, it also baffles the company, A and B company, that Mr. Musa had to wait as long as 8 months before reaching back to the company to this effect. And the fact that after this long period, he's coming with a petition. He's not coming to, solicit or ask. He's coming with a petition against the company. Is really amusing because we had no idea of the fact that he didn't get any of this email before now. And the record duly given to the company state that every email was sent to all the employees. On this ground, we are saying that we had not breached our contract with Mr. Musa to this regard because we were not aware of the fact that he didn't get any of these emails before now. And if we had been duly informed, effort would have been made to correct that mishap. On this ground, we are tabling before this tribunal in our own due benevolence and kindness that ARB company will be offering Mr. Musa a sum of 50 million naira as compensation for any damage he might have, undertaken in this period, and a privilege to come back and work with the company. However, if he's unwilling to come back to work, he'll be given a sum of 10 million naira, and that is all we'll be able to offer for this issue.
So the claimant, you have what the respondent has said. What is your take on her statement?
Okay, thank you very much. I heard carefully what she had said, and she tried to base liability on Mr. Musa, stating that after 8 months, he did not do anything at all to even say, okay, he did not receive any instruction from the company, and therefore they are not supposed to be held liable for breach of contract. Well, we know, I think it's clear to both of us that we are supposed to understand the rules of engagement and the rules of employment and also labor law. As councils representing both parties, we understand that under contract there's something called under labor law, there's something called vicarious liability, where a company is held responsible for the act or negligence of their staff. Now, rightfully, the company had instructed that the HR personnel would reach out to Mr. Musa and give him instructions on how he's to go about his work, which was not done. That means there was a duty to be done, and an omission was not done by the human resource personnel. And Mr. Musa should not be held liable for the negligence or for the lack of duty of their human resource personnel. They are therefore vicariously liable for the acts of their human resource personnel, and they are to compensate Mr. Musa and ameliorate the hardship that has been done by the acts of their staff. Thank you so much.
What is your take on what the claimant has just said?
Okay, I have carefully listened to a submission, and I want to clearly state before this tribunal that A and B company, we are not in any way denying liability for any act of our employee. Mind you, I like to state here that the said human resource personnel have been a worker in A and B company for over 2 decades, and she has never for once been found to have been negligent in her duties. And over the years, we have come to trust her in carrying out our operations. And so, since on the 3rd of April, as writing states, documents which have been tabled before this tribunal, she submitted records to the effect that all employees have been duly given emails. We didn't take particular efforts to pry into it is not in the operation of the company to pry into the duties of whether that was truly carried out. So it amazes me that, especially to the fact that the said Mr. Musa had earlier called the general manager of the company to ask about information. And after weeks of not getting anything back, he didn't bother to call to get necessary go ahead on what to be done. He just waited for over 8 months, and now he's coming upon the company to ask for damages, which seems rather unfair to the company because we're never given prior notice of this particular event. And records with us shows that every employee were given due email to this effect. And so, first of all, this suit is like a surprise to us as a company. But all in all, we are willing to negotiate with the claimant on this issue and come to considerable grounds. However, we still stand on the fact that we are not going to accept full liability and hence will not be liable to pay the outrageous sum he is seeking for.
Ephraim, you are
Hello, Mr.
muted.
Ephraim.
Okay, sorry. I want the claimant to say her summation, looking at the time we have. What is your summation on the subject matter before the respondent will bring our own summation so that we'll bring a conclusion on the whole issue?
Well, as I had carefully stated, bearing all the facts that I have brought before this session today, the the respondent has no evidence to prove that Mr. Musa's mail was part of the emails that was sent, that messages were sent to. There is no proof on my end that any mail was sent to Mr. Musa, who is my client. From everything that she has gathered before, as brought in as evidence, Mr. Musa's mail is not found there. So there's incompetence on the part of the human resource personnel who had even threatened Mr. Musa on a private basis. But I wish not to bring that matter before this arbitration session. But it's an act of negligence on the part of the human resource personnel to not forward the instructions to Mr. Musa, which made him not work for 8 months. How can a man not work, a man who has a family not work for 8 months, and he expects him not to be hurt? And the company cannot come now to say they don't have any liability in it, because it is their act of the employee that led to the breach of contract between A and B company and Mr. Musa. So I would submit that the company is liable for the breach of contract held by which was caused by their human resource personnel, and they are to compensate Mr. Musa for the damages that occurred to him for not working for 8 months. Thank you.
Okay, respondent, your summation on the whole issue.
Okay. I will humbly submit on behalf of ARB Company that, first of all, I heard the claimant counsel mention about some private affairs between the claimant and our human resource personnel. First of all, we cannot be held liable as a company for the conduct of our employee that happened outside the jurisdictions and the workings of employment. If whatever occurred between our client and the complainant in this matter was not within the confines of the job or the office environment, we cannot be held liable for whatever has happened between them. However, we are not failing to acknowledge the failure of the um the incompetent act of our employee as the human resource manager, because truly, as she has said, there is no evidence to show that emails were sent to Mr. Musa if drew after careful consideration. But however, we still want to rightly point out that this information is not one that the company as a body was fully abreast with before the suit was filed. And because we were not aware, we couldn't do much to remedy the issue. Have I point out that over the years in the running of A&B company, there are times we offer employment to a number of persons, and these persons never showed up for the employment, even after seemingly accepting it. And it is normal to see that people decline employment offers every now and then. And it was normal for the company to just assume that Mr. Musa was no longer interested in the employment offer. Hence, he didn't bother to come and do anything all these 8 months of waiting. And so, because of this, the company is stating that we cannot be fully held liable for all the plights that Mr. Musa went through this period. And we still maintain our submission to pay only but a fraction of the humongous sum he is asking for. And that will be all we have to offer. Thank you very much.
All right. Thank you so much. After listening to the both parties, it is clear that this is a complex and sensitive matter that requires a careful consideration of all evidences and arguments presented. As an arbitrator, my role is to consider the facts, the evidence, and the applicable laws, and to make a fair and just decision. I hereby award the company A and B a liability of settling the claimant, which is Mr. Musa, the sum of 20 million naira as damages, and also reinstating him as their staff in their company. I appreciate the efforts made by both parties to provide clear and persuasive arguments and to present evidence that supports their position. May God bless you all. Thank you.
Thank you very much.
Okay, thank you so much, Group One. Thank you, Melody. Thank you, Ephraim, and thank you, Favor, for stepping in for Group Two. I mean, sorry for the mistake. To hold the simulation on behalf of your group. So, if we have Group One ready, please you can go ahead and start with Group One. Our Group One mentees ready for their simulation. Group One, please, if you're ready, turn on your videos and your audio, and you can go ahead and start with with the mediation simulation. Hello, Miss Gloria. Please, can you confirm that your group is ready for the simulation?
I I guess the Austin is
Hello, sir. I
Yes, I
think
can hear you.
it's only me and Gloria that joined this evening. It's only two of us.
Okay, please, do we have other members for groups for group one on this particular call so that we can have someone step in to represent the people who are currently or the person? How many how many parties do you have or are you supposed to have in this particular simulation session?
The councils and the arbitrator is just only Gloria that joined this evening. The other two persons they are not here, and I've been
Okay.
calling them for them to join, for them to come online and join. Like they're not taking their calls.
All right, thank you, Mr. Augustine, for the update. So please, can we identify group one members that are here on the call? Do we have group one members on the call? Please, if you are a group one member on the call, please on your camera so that we can see you all. Okay. Oluwatimileyin. Who else do we have here for group one? Do we have any other group one mentee as apart from Oluwatimileyin? which group are you in?
Oh, good day, sir. I'm in group one.
All right. So please, if you're in group one, please turn on your video, if that would be possible. Okay. All right, Nita. So for group one, please, we'll need to have, since that we don't have two of the council here, I want to assume that every other member of the group, even those that did not necessarily um, volunteer in the first instance to take on the simulation, I want to assume that the whole group participated in carrying out the simulation itself. So please, we would like two people from those who, um, for those from those who are part of this particular group, but are still in the know of the simulation. Please, can we go ahead and step in?
Okay,
Can you go ahead and step in?
Mr. Demo,
Yes, sir.
okay, this is what we'll do. Augustine, who was supposed to serve as the arbitrator.
I think Gloria. Then me, Mr. Musa, counsel.
Okay, so Gloria, you are
I mean,
the
Victoria. Victoria was supposed to be the arbitrator.
Where is Victoria?
She's not here.
Okay, Gloria, can you serve as an arbitrator? Gloria, can you hear me?
Oh, these people want to put someone on their table. Guy. This is so difficult to see.
Okay. Um. Okay. Favor Ngozi. Ngozi. Melody, please turn on your video. Ngozi, turn on your video. Ephraim, turn on your video. Okay, so Melody, you are going to serve as an arbitrator. Yes,
I'm in group two, not in group one.
yes, I know. Then Glory, you which role are you supposed to play? Which role are you supposed to play? You are muted.
The company lawyer.
Okay, company lawyer. Chima,
Yes.
what role are you supposed to play? You are muted.
Counsel to Mr. Musa.
Okay, so we are supposed to have we are supposed to have 5 participants. 1 arbitrator, 2 Mr. Musa, that's the employee, 3 the representative of the company, and then the lawyers. So Gloria will serve as the lawyer of the company. Olua, you are in group 2, right?
No, I'm in group one.
Okay. So Chima,
Sir, I'm here.
okay. Melody, you are going to be the arbitrator. Then Chima, say again, what role are you supposed to play?
Counsel to Mr. Musa.
Okay, counsel to Mr. Musa. So we have arbitrator, we have counsels to the company and to Mr. Musa. So now we need Mr. Musa and the representative of the company. So Gloria, you need to choose among those that are here. Chima, you need to choose from your group members that are here. The person that will serve as Mr. Musa, or let me see, Mr. Ephraim.
Yes, sir.
Yes, can you serve as Mr. Musa?
Okay, sir.
All right. So who will serve as the representative of the company, please? Okay, Olua, you are going to serve as the representative of the company.
Yes, sir. I would love to ask, is it as a counsel or a representative of the
No,
company?
as the representative of the company.
Okay, I would volunteer for that role. Thank you, sir.
Okay, so this is what is going to be. It's actually supposed to be like a court setting. So the arbitrator is going to introduce the matter. Ordinarily, we are supposed to have the registrar. Let's say, is there anyone who wants to volunteer as a registrar? Okay. So if we don't have a
Okay.
registrar, so we have.
I don't have my hands full, so I can volunteer and take notes as well.
Okay. Okay. That's fine. You are going to serve as. No, that will not be, because you will be testifying. You as this thing, you will testify. So we need someone separate to serve as this thing. Nita, can you on your camera? Let me see and know who Nita is, please. Okay, Nita. Okay, so now it's normally, let's assume the matter will be called. This is the matter that is before the arbitrator, right? And then the arbitrator takes over the proceedings. Okay, so Victoria has joined. Victoria, where do you belong? Are you for us or against us?
My network is having issues. Good evening.
Okay, your network is having issues.
Yes, it's disconnecting by itself.
Can you change your location? Is it possible? Maybe it's network in where you are also.
It's about to rain where I am, so I can't step out.
Okay. Okay, where you are, can you change the direction from where you are to another location in the house? Okay. So okay, let's have Victoria.
Can you hear me?
Victoria, yes, I can hear you. Victoria was supposed to serve as an arbitrator.
Please, can
Can you
anyone
take
hear me?
Yes, we
Yes,
can hear you.
I can hear you.
Can you hear us? Can you hear us?
No, I can't hear clearly. Oh. My network is shaking. It's even shifted at some point.
That's interesting.
Airtime is disturbing at my end.
Okay, so it means that we cannot assign a role to you per se, because your network may
No,
just go off and we may not be able to. Okay, so let's now go ahead. Let's assume, I don't know who again is Ngozi. Ngozi, can you on your camera? Let me see you. Ngozi is not here. All right. So okay, Ngozi. Ngozi, what role are you taking?
Well, I'm a group 2 member. We just finished our session.
That
And
notwithstanding.
I'm Ogozi, not Ngozi.
Oh, Ogozi. Okay. Sorry. Ogozi. What's the meaning?
It means blessing. It's actually related to Ngozi, but it's not Ngozi.
Okay, thank you. All right. So arbitrator. Who is the arbitrator? Melody, right?
Yes, sir.
Gloria is the counsel to the company.
Yes, sir.
Chima is the counsel to um
Mr. Musa.
Mr. Musa. Then
Yes, sir.
Ephraim is Mr. Musa. Then Olua is representative of the company, right?
Sure.
Olua.
Yes, sir.
All right, thank you. So Ngozi, you are going to serve as the registrar. Now you are going to take note of the name, the arbitrator. You are going to take note of you are the registrar. You take note of the names of the parties before the arbitrator, the representative of the company, the council, and all of those things. So take note of that. So Madam Arbitrator, this is it. The matter is called, you introduce yourself, what the matter is for, and then ask the person who, ordinarily we are supposed to have parties file their processes, like you have filed your point of claim, you have filed your point of defense, the documents and whatsoever all are before the arbitrator. You have had your preliminary meeting, you have issued your uh the order of direction, and then maybe you are now here for hearing. So the hearing is a normal procedure that you follow. So depending on what you have agreed, parties, the arbitrator will now usher in the process. The what do you call it? The um the the complainant, the person who initiated the procedure, will go first, present his case. Now the lawyer to the counsel will be the one to you announce appearance. Is just normal. The way you see court process is just that this is a private way of resolving issues. So parties are there. The lawyers will introduce them, announce their own appearance and whatsoever. Then arbitrator, you call on uh, uh, the witness, which will happen to be either the representative of the Musa himself. He will state his own facts. If he has any document, draws the attention of the arbitrator to it. Arbitrator, if he has any question on those things, he asks. Then after that, the lawyer will have opportunity to ask questions. And after you're done, the respondent takes over, presents his own case. If there is any cross-examination question, you do. If there is none, you close your case. After that, if you want to address the court, you address the court and draw the court's attention to important facts and the law that possibly supports what you are trying to establish before the tribunal, so that the tribunal will take note of that. Registrar will be taking note of the processes and whatsoever that is happening. If there is need to pass across document or to swear the witness or to whatsoever, the registrar is there to do it. Are we together? Okay, so I just give
Yes,
you a
sir.
little, yes, I just give you a little background so that you can now proceed with your activity. So, Madam Mediator, your registrar is also there. So go ahead. Madam Arbitrator, rather.
Good evening, House. My name is Organetica Melody, and I'll be standing as the arbitrator in this matter, as I have been appointed by the Institute of Chartered Arbitrators to oversee this issue. I declare myself to be impartial, and I say this proceeding will be totally confidential. I also want to state that the matter before us is one between Mr. Musa and A and B company. We'll be looking into this issue, and any award I will be giving on this issue will be final. And upon appeal, will be upheld. So I want to adjourn parties to cooperate with me so that we can reach a good end, a significant goal. So I would now ask the parties to please introduce themselves.
You're acting as though you do not have a registrar. Who was supposed to be your registrar?
I don't know the person's name. The person's name.
Because he was supposed to serve as the registrar, right?
Favor Ogozi. Yes,
Sorry.
Favor Ogozi.
Sorry, I don't know how please pardon me. Ogozi, Favor,
It's fine. You
please.
can me as Favor.
Okay, thank you.
Okay, so I'll go over again. Good evening, House. My name is Ogenetiga Melody, and I'll be standing as an arbitrator in this matter, having been appointed by the Institute of Chartered Arbitrators to oversee this issue. And with me today is my registrar, who will be taking record of this proceeding, Ms. Favor Ogoli. The subject matter before us today is a matter between one Mr. Musa and the A and B company. I declare myself to be impartial, and I resolve that this session will be totally confidential. Any agreement or the award met at this arbitration session will be final, and upon appeal will be upheld. Having stated this, I would like the parties to please introduce themselves.
Okay, good evening, everyone. Augustine Chima Chidi, counsel to Mr. Musa in this arbitration process. Thank you. And the complainant, sorry.
Good evening, everyone. I am Gloria Jude. I'm counsel representing A and B company, the respondent in this matter. Thank you.
Okay, thank you very much for that introduction. So I would like the complainant in this matter to proceed with his case.
Mr. Musa, are you there?
Yeah.
Oh, okay, you can go ahead, Mr. Musa.
Okay. My name is Mr. Musa, and I am an employee in a company in Abuja a few years ago. But after I received an offer from AMD company in Kaduna, I wrote my application letter, have sent to them and my CV. And after a while, I've received a call, which they called me for an interview, which I have fully attended. And the job was offered to me. I resigned my job in Abuja. I fully take this job here in Kaduna, even moving with my family from Abuja to this place. But upon resumption, suddenly there is a lockdown, which couldn't make me to fully take up my job proper. So after the lockdown was declared by the state government, after some days, I reached out to the GM who told me that I should not worry. The human resource manager will reach out to me on how to work remotely during the lockdown. Over this period, I've not received any call or any message from the company, and nothing was reached out to me either from the GM, the human resource manager, or any other person from the company during that period. After this stay for 8 months, only God knows what I passed through, my family, myself. It was intense pressure from my side. So after this period, I tried to reach out to them, no any information from them. That triggered me to look for a means of addressing this issue I'm facing with the company. So that's why I filed out a case to this arbitrary process. I want my case to be resolved and find out my stance. Thank you.
Thank you very much. So what does the respondent have to say to this? Counsel to the respondent.
Okay.
Do you have
Thank
questions to ask Mr. Misa based on his submissions?
No, need to explain the matter as it is. Okay. A company is actually a company properly registered in law. Through the Corporate Affairs Commission, and so it understands all the laws and regulations regarding employment and then contracts of this nature. So A&B company fully also know that Musa Musa is an employee of this company, and that he was fully employed with all his contracts of employment, all his letters of employment, everything duly registered and all of that. Now, it was just at that process of him completing his employment contract that the lockdown came, and there was nothing the company could do but to promise all the employees. And we have evidence to show that every one of them were sent notice, they were sent chats, messages, regarding the remote job to be done during the lockdown. And all the others, they acknowledge the receipt of these messages, and they turned in and did their works, accordingly. Just Mr. Musa, for whatever reason, we did not see him. The company did not see him. He did not receive any message, whether he would attend or he would not attend. Hello, ma'am.
Thank you very much. I want to know, do you have questions for Mr. Musa based on his submission?
Yeah, I want to ask Mr. Musa, He said he was had all the he had so much issues with the fact that since he was not called and was not paid, ask him, does it mean that he did not receive? Because the company did not enjoy him. The company did not benefit from his resources, from his wealth of knowledge that we saw, that made us to, what are these things? Okay. That made the company to employ him. The company did not benefit anything from him. Now, is it saying that he did not in any way receive the messages sent to others as the way others received the messages? Is it saying that he did not receive his own message? That is my question for Mr. Musa. Thank you.
Thank you very much. Mr. Musa, you are going to answer that question. But next time, Council, when you are directing your question, can you direct it to him? Like, ask him, did you not receive the messages? Be more direct. Okay? So please, Mr. Musa, answer the question.
With due respect, ma, I've not received any message.
Because we have list of these messages sent to all the employees.
My email page. I've checked all the sales from the company. I didn't get you, ma'am.
Yeah, because as I mentioned, the company being a company registered in law, then you will not get paid when you do not work. Okay? And so that is where the issue really is.
Is that all the questions you have? Counsel to the claim to the respondent.
Okay, and I want to ask him, Mr. Musa, the company promised you. Hello, Mr. Musa, you can hear me?
Yes, I can hear you, ma'am.
Hello, sir. Yeah. The company promised you, go home. We are going to send you a message, okay? As regards remote job during this lockdown, and you went home. Now, after a while, and you did not receive the message, what were your actions? What did you do to ensure you receive your own message, to ensure you find out what is actually happening with the company as regards their promise to you? What did you do?
All right. After a while, I said, I tried reaching out to the company. That's when I reached out to the GM. The general manager told me that I should not worry. I will receive an instruction from the manager who will tell me how I'm going to work remotely during the lockdown. And I've been patiently waiting to receive any call from human resource, and I did not receive any. I tried reaching out to the company. I reached out to the general manager. You can call him to verify my claim.
Arbitrator, I believe there's room for re-examination.
If you have questions to ask him, please do. Go ahead.
Okay. My question to Mr. Musa.
Yes, sir.
I believe you know the HR very well. And did you wrote to the HR in particular demanding for instructions from the company?
My relationship with HR has been a bit, not normal due to our personal.
I'm asking you if you wrote to the HR in relation to the instructions from the company, not about.
I've not done that one because of my relationship with her.
But the general manager told you that you will get a message from the HR. Have you gotten any message from her?
No, I have not gotten any message from her.
Okay. I believe the company have their HR in court. The HR should tell the arbitration process why she have not written to Mr. Musa, my client, giving him instructions to which he's supposed to carry while working from home. Thank you.
Okay. The representative of the company will now speak.
Sorry, good day. Can anybody hear me?
Yes, we can hear you.
Okay, so as the representative of the company, I'm Miss Adama.
Hello.
Hi.
Sorry. Can you hear me?
Yes, I can.
Has the applicant, that's Mr. Musa, is he done with his case?
I got instruction from the arbitrator that I, as the representative of the company, cannot proceed with my
So
submission.
you have your own time. Counsel to Mr. Musa, finish what you are doing. Present your case. When you finish, you close your case so that the company can open up their own case, So if you are
Sir,
done, let it be that you are done.
counsel to the
I'm
claimant.
here.
Are you with us? Do
Yes,
you
I'm
have
here.
any further
Okay.
submission?
Yes. Thank you very much. My client, Mr. Musa, has stated before this process. He has made his statement very clear and open that when the lockdown was called from the government, that they had to go home, and he got an instruction from the company that he would get a message from the HR, to which he has waited for several months, several days, and he has written back to the company demanding from a message from the HR, and none has come from the HR up until now. To which means this is a negligence from the company, and it's from the HR, and it is not his fault that the HR doesn't want to reach out to him, or doesn't want to write to him, or still obey the instructions from the general manager, which is the head of the company. And this means that the HR has an ulterior motive to suffer my client, Mr. Musa, to which made him to stay for months without getting his payment. This is a family man, married, and he has kids, and he has people to take care of. And then, due to whatever the HR feels, and the HR's negligence, to which have caused him this undue hardship, making him to stay for months without getting paid, and from the contract employment, the agreement he signed with the company, he is not supposed to enter into any contractual agreement with another company until he's done working with A and B company. And this has made him to stay loyal to the company without applying for work to another company, to which means he is still entitled to all the salaries and allowances to which the company from the initial time, from ab initio, owe to him, and to which they signed in the agreement, in the contractual agreement, that he's supposed to be paid certain amount of money at the end of every month. And this he has written to the company severally and has gotten no response, even up to the point that he had to write to the general manager demanding the instruction, to which was given to him from beginning, that he is going to get a message from the HR. And I believe the general manager of this company has written to the HR demanding that she should fulfill her duties. This is her obligation. This is her responsibility as an employee of the company, to always issue out messages to the workers, to other employees of the company. And due to how she felt, or whatever that she feels that she's holding against my client, Mr. Musa, this has made her not to issue the instruction or the letter to Mr. Musa. And this has caused undue hardship to my clients. And also, according to the compensation at 210, to which provides that so far as an employee is still an employee of a company. He deserves the total compensation to which comes from the mental stress or injuries while working with a company. And this particular is a mental stress for keeping a man that is married and has kids and is still working with a company, keeping for more than 12 months without getting any salary. This is a mental stress. And I believe the company, they are also obedience to the law, and they are also law-abiding companies. They believe that yes, the law is what should rule them. And I pray that in this arbitration process, that the compensations, the everything that is accrued, the salary of my client, will be paid to him accordingly. And also, the HR should be held responsible for not discharging her duties, her responsibilities, and her obligations to which she owes the company. Thank you.
Thank you very much, Mr. Augustine, representative of the council to the company. Having heard your submission, I would like to hear from the respondents in this case. So can I have testimony of the representative of A and B company?
Good day, Madam Arbitrator.
Good day.
Sorry, can anybody hear me?
You may proceed.
Thank you, Madam Arbitrator. So, good day. I represent the ABC company, and I am Miss Amada. So, on the fateful day when I met Mr. Musa, I met him at Kaduna when he came for his final documentation to the HR resource manager for the application of his job. And one thing led to another. One thing led to another, and you know, passion got a hold of us, but still, we decided to move past that stage as two considerable adults would actually do. Only for me to get a message from Mr. Musa that after taking advantage and deriving pleasure from the act that we performed, bringing to my notice that he has a family to cater for. I mean, I was so downcasted because I felt cheated for him having carnal knowledge of me as the innocent person, and knowing fully well that he has his obligation as someone's husband and someone's father. So I just did what any rational woman would do and made a threat that I was going to make his life unbearable at work, which I didn't even know that at the end of the day he didn't get the mail from the HR. So yes, that's the crux of the matter, Madam Arbitrator.
If I get your submission clearly, I want to know the relationship between your testimony and the case at hand right now before the council can proceed. So I need you to buttress more on your testimony, please, for record purposes.
Okay, thank you, Madam Arbitrator. So I happen to be an employee in the already existing A and B company, and I happen to be an old-time friend of Mr. Musa as well. So my relationship in this instance would be a representative of a company, which is Miss Amada.
Okay. Okay. Now, having listened to the respondent, I want to know if the counsel to the claimant have questions.
Yes.
So
Yes,
ask
we have.
more questions. Okay.
Yes, we have
You may
questions.
proceed.
Okay. I believe the representative of A and B company is Ms. Adama, who is the HR manager of A and B company. And
So,
also,
okay, sure.
from your statements, you stated in quotes that you met my client Mr. Musa in Kaduna, and you guys got carried away with passion and pleasure, and after that Mr. Musa then told you that he's cutting it off because he's married, and then you stated that he took advantage of you. Now I want to ask you a question. Were you in a relationship with him at that moment when you guys had the passion and pleasure? Were you in a relationship with him?
No, I'm in no relationship, or I'm in no
Okay,
affiliation.
thank you. Also, I want to ask you another question. Um, During the passion and pleasure, was it consent? Did you consent to that?
Yes,
Yes
it
or
was
no?
of consent, but might I
Or you
had that
consented
the
to
fact
that?
never
Um,
stated that Mr. Dama was the HR of the company. So are we fabricating facts here? He stated that she was an employee, not the HR of the company.
okay, okay, thank you. Um, you are not the HR of the company, and then
Yes, I'm an employee of the
you
company.
are an employee of the company. You are an employee of the
Yes.
company. Okay. The relationship or the passion and pleasure you had with the coitus relationship you had with my client Mr. Musa was consented. You consented to that.
Yes, we
Okay,
were
now
carried away, and I consented negligently because I was not aware
negligently.
that Mr. Musa had a family. He was a husband, and he had fatherly obligations to his children.
I'm sorry, I asked you only a question.
Out
Did
of
you consent
ignorance.
to that? Did you consent to that?
Out
Did
of
you con-
ignorance.
My lord.
Thank you very much. Thank you very much. Um, because he came to you and told you that he's married, and then he would like to cut off the coitus relationship you guys had, and because of that, you got angry and chose to make his life miserable. Am I right?
Perusing the facts, it never stated that I made his life miserable. It was a quote
This
in
is your
text
statement.
that
This is your
she
statement
promised,
here.
a promise that has not been fulfilled yet. So technically, I didn't make his life miserable.
So you're already threatening him, and
Please,
it is assumed that you are the one that
and
made
counsel,
HR not to send him his message.
can we
Um,
maintain order in this place?
That is fabricating of facts.
No, it's not fabricating of facts.
It is.
You said
Cancel,
you are
you're
mis.
fabricating facts.
Okay, thank you very much. From the case we have in this court, you
Counsel
and
to
Mr.
the
Adama.
counsel to the claimant, please. I want to say something before you continue with your, should I call it an argument session or a cross-examination session? Please, we are not fighting here. Please, you can ask questions, and I will appeal to the respondent to allow him ask his question and answer accordingly. And then I want to state that it appears to me that the parties and their counsels are not fully abreast with the issues or the matters in the case, because from what was submitted to me, they said Ms. Adama is the HR of the company.
Exactly.
So if you are standing here as Ms. Adama, we are obliged to agree that you are the person, the said HR, and you came to represent your company as the HR of your company. So let the questioning continue, and I want you to give me, answers. Don't try to confuse the arbitrator. Thank you very much.
Okay. Miss Adama, from the case we have here, the HR is Miss Adama. Are you Miss Adama or not?
I am Miss Adama, but after proper perusal of the facts of this case, it never in any way stated that Miss Adama is the human resource manager of ABC company, except, right, I do not know, maybe the organizers of the arbitration stimulation section had changed that. But when I perused the facts, Miss Adama was not the HR. Sorry, I'm just asking this, like, is Miss Adama the HR?
Okay, now I don't know what's going on anymore. Are we questioning the fact like we don't know what is happening? You are Mr. Damba, you know the role you played. Let's not question it as though we don't know the whole scenario in this matter. So because of this, I'm going to read the statement that
Okay,
has been brought before this arbitration.
Mr. Chima, do you have
Sir.
further questions? If you have further questions, ask please.
Okay. Let's assume we are done with the human resource manager, and
Okay.
Mr. Adama in this case is the human resource manager. Even from the fact of the case, Mr. Adama is the human resource manager, and Mr. Adama has admitted before us here that she got upset and she threatened my client, Mr. Musa, and promised to make his life miserable, to which means she intentionally did not want to send the message to my client, Mr. Musa, because of the previous relationship they
Mr.
both
Chima,
had.
Mr. Chima, is this question,
Chima.
are you asking question or you are making submission?
I'm making submission. I'm done with my question.
And I thought the company representative as a lawyer. And I don't understand what is really happening. The lawyer kept quiet and was just watching and looking. Okay, please. If you have further question, ask. If you don't have, please let's proceed.
Okay. I have one more question. And Mr. Adama, as the human resource manager, did you issue out the letter as instructed by the manager of the company to my client, Mr. Musa?
Yes, because in ABC company, we follow due process. The day I met Mr. Musa, he came for the documentation of
I asked
his...
a question. Sorry, Mr. Adama, I asked...
Yes, I follow due process.
Miss Adama, can you stick to answering the question?
And when Mr. Musa reached out to the manager, telling the manager that he has not received any letter from you, did you react to that?
Sorry, could you remember the question?
When the general manager called you, telling you that Mr. Musa has not received his own letter, did you react to that positively by sending another message to Mr. Musa?
General manager call her.
Yes, would have to refer to the fact that I didn't get a call from the general manager.
Thank you very much. That's all. Thank you very much. That's all.
So, counsel to the respondents on this matter, do you have any questions to clarify the testimony of the representative of A&B company?
Yeah, just number one, just like the last question that came and the respondents rightfully answered, the general manager never called her, never asked, only said, according to Mr. Musa too, and that was what it was, that the HR would get back to him. And then he said he never went back to HR. He just went only to the general manager. He didn't go back to HR to inquire because of his personal relationship, whatever relationship it is. And you should also know that his interactions or relationship with the HR or the Mr. Adama does not have anything, cannot influence the professional output of the company or anything, cannot influence anything about the company. That one is on his own. If the HR has done anything wrong, the company has an investigative unit who would investigate it and give her a due punishment due to that. But then he was meant to go back to HR, just like according to him, he went to the manager. He was meant to go back to the HR, but for not going back to the HR to inquire and to hold it for her. Now, HR has said that she sent the letter the way she sent to others because the company follows due process. Okay, she never allowed the personal relationship to affect whatever she was meant to do. She sent the letter as a bulk SMS to everyone. Okay, so now he did not receive his own. According to him, he was meant to go. Mr. Musa, please, I'm talking to you. I hope you can hear me. You are meant to go back to HR to inquire, since manager made you to understand that it was HR that is responsible for that. I allowed it. So now we will not say that Mr. Adama should not professional relationship between the company. It's not her position. It's not her position to say who would come for the remote job or not. The company has already given the mandate, and she was meant to follow up to the letter, and I believe that's what she did. So it still falls back on Mr. Musa. It was his fault not to follow up duly to ensure that he received what he was meant to receive. That's my submission. Thank you, Madam Arbitrator.
Well, having had the submission of both parties in this arbitration session, I will now come to a conclusion by giving my rule on this matter. The parties have rightly stated and given their various arguments as to why they think this matter should be decided in their favor. However, I would like to point out that from the submission given by the council and the representative of A and B company, it shows that there are some shortcomings in the operations of the company, as proper informations are not being, decimated and designated as it should be. And so therefore, because of such, inconsistencies, this was resorted to. However, I would also want to point out that from Mr. Musa's testimony and from the arguments rightly presented by his counsel, that there was also failure on his part to make necessary efforts to ensure that he got all the information or all he needed in due time. And the duration of time he gave before taking any action is quite long and elaborate. Hence, he suffered unduly because he wasn't proactive enough to take necessary steps. Having pointed out this, I would like to rule at this junction that A and B company has been held liable to Mr. Musa in damages as due to the inconsistency of the operation between the HRO to the general manager. He had suffered unduly this month. But however, I would not be awarding Mr. Musa the sum of 20 million naira as he has requested. I'll be saying the A&B company is liable to Mr. Musa with the sum of 5 million naira, and he will also retain his employment in the A&B company. 5 million naira for damages, and is expected to be reinstated in his office as an employee in A&B company. Having established this, I would like to state now that this award is binding on both parties and must be followed. And even on appeal, this award will be duly upheld. And at this point, I will close this arbitration section. Thank you very much.
Thank you. Thank
Thank
you.
you.
Thank you.
It's going to be paid.
Okay, thank you very much. Thank you very much, everyone, for participating in the who took out time to participate in the simulation. Well done to all of you for putting in the effort. I want to say a job well done. I want to now hand over to our mentors to get their comments and feedback on the session as it was handled by the mentees. So, Mr. Nyacham, over to you, sir.
Okay, so
Um,
can we on our camera and let's have a snapshot?
all right, so please can we turn on our camera once again for a quick snapshot of this particular session? Sorry, please just give me a minute. I'm coming. All right. Um, all right. Thank you very much. We're done.
Okay, thank you very much for the presentation. I must congratulate and appreciate all the participants for what they have done. You know, I just saw that if only they took time and do a little research, do some work, they would have a wonderful session. But I was the session got interesting at the point. The first group, that's group two, that presented did their best, you know, but they made it look like more or less like a, a combination of procedures of mediation and that of arbitration, you know. So but generally I can say that you know, even though the process was impromptu and roles were assigned to persons even when they were not prepared, but you can see that you did wonderfully well. I wish all of you would take up the challenge to ensure that you become certified mediators, certified arbitrators, certified ADR practitioners. It will be very, very interesting. This experience that you have, even those who do training sometimes, they, they may not have those kind of opportunities where you take a role and then you have the kind of role plays where you have mentors or trainers give you feedback, give you guidance. I can say that this is actually a very great opportunity, and I appreciate all of you for the role you have played. It is very, very impressive, so to say, except that, you know, there are a lot of mix up here and there because you do not do what you're supposed to. And the last time this mentorship was supposed to be concluded last week, it was extended so that you have the opportunity to uh, do a proper research and then do a kind of practice so that when you come, the process will be seamless. And if you have done so, some of the inputs that your mentors will be making will actually have a lasting effect on you, you know, and that will be very, very wonderful. Because eventually, when you partake in the trainings, you will not be going there as a novice. At least you have skeletal knowledge. When they are making some explanation, you see some A and B adding up together and giving you meaning because you have seen it somewhere, you have participated, even though it was not properly a full-fledged something, but at least you have idea here, knowledge here and there. You know, it will make more meaning to you. So please, when you have opportunity to do something like this next time, you try to give it your time. The organizers JIIPCC are doing their best. Settlement House are doing their best to make sure that they are always available to give you the needed support, the needed guidance, the needed instruction that you need. It's just that you had a blank check, but you didn't actually utilize it. You didn't write enough, amount on it to be able to gather what you need to gather and prepare for the days ahead. So, but I hope that the time we have spent together has been meaningful, and you have had announcement on some of the trainings that are coming up for those who are interested. Please, I would love to see all of you attend the trainings. You will really appreciate it when you do a professional training and you see some of the things you have learned. And one thing I've noted also is that when you are doing a mentorship program like this, some of the sessions we have, you remember we have a session where you were doing presentation. The mentors were there to make a presentation on important aspects. It seems some of you have not taken note of some of the things that have been said. Those are very, very important because they are the foundation upon which you are coming to do the practicals you are doing. So if you take note of them, you now know the procedures. All these matters were talked about, how arbitration is commenced, the agreements that leads to it, whether it is institutional or whether it is ad hoc, the appointment of the mediator, the arbitrator, and all of those things, they are taken care of during some of the section week 1, 2, 3, before we came to week 4 and 5 that we were doing practicals. So please, let's like the Bible will say, whatsoever your hand finds to do it well. Please, when you have opportunity to do something, give your time to it, because you may not have opportunity to do that thing again. And the reason why you are here is for a purpose that you may understand later. So please, let's try as much as possible to be taking advantage of opportunities when they come, utilize them, and I believe that all of you will be great mediators and arbitrators. Now, having said so, I would like to call on my colleague, Ms. Pa. Please, if you are with us, can you put on your camera? Ms. Pa?
I'll get back to you, please, Nacho. I'll get back to you.
Okay. All right then. Now, I can see somebody's hand up. Do you have a question? You have a comment?
I have a question.
Okay, so please, let's have your questions, your comments. How do you think you perform? What is...
I'm back, Nacho.
Okay, somebody wants to ask a question and then we will go on.
Okay.
Please, Olua.
Okay. Can I go on now?
Yes, please.
Okay, thank you very, very much for the stimulation. I mean, I wasn't supposed to partake, but I did. And I knew that the litigant in me just came out to argue. But I have a question, right? After proper perusal of the facts of that particular stimulation case, it didn't state that Miss Amada or was the HR. So why did we have to infer that she was? Because I was even looking at it from the perspective that, since the fact didn't actually state it, it would have been like an easy peasy cake for us on the other side of the party to actually submit our arguments in such a fantastic way that perhaps there's a misrepresentation or something. But I understand that part. Also, secondly, the question that I have, right, is what role exactly does the representative play? Is the representative just supposed to give their own account of the incident, or they as well can defend themselves even while their counsel is still present? And for a counsel, the third question, right? For a counsel, how do you give that submission that is unquestionable? I'm so sorry. Then the fourth question, right? I would love to ask, can you give tips? For example, now we just did the simulation and the arbitrator gave an award. Can you give us tips on how to come up with awards if the next time we are role playing as an arbitrator? So it's not one that is questioned or can be taken to appeal in court. So thank you very much. Those are just the questions I have.
Okay, Olua, we are going to have there is going to be a settlement house. Shati is having a webinar tomorrow on the arbitration process. I think it's on your platform. Please, if you have not registered, register for it. We have an expert who is going to take us through, from the beginning to the end. That's normally what is involved. So please ensure that everybody in this platform should ensure that you registered for. It's free. The webinar is free for everyone to attend, except those who want certification after the webinar. But it is free for participation, and you can encourage your family, your friends to partake in. Now, you see, the question you are asking is because you have not prepared. Well, the whole process was just, I just had to come up and see how I can put one or two things together so that we can have a good session, And you are not prepared for the session. Now, you do not even know the procedures. You did not read up the mentees, all of you. I don't think you have read up the procedures or what is supposed to be, how the process. Normally, you have not even shown us that you have had a previous meeting. You have had your first preliminary meeting, and maybe it was from the preliminary meeting that you have fixed a date for hearing. You have not stated anything. There was no connection as to for people to know that you have had a meeting where you have decided certain issues and matters, and now today is fixed for hearing, and there was nothing like that. And that was because you never had the time to look at the processes. Now you see the arbitration procedure is not like mediation. It is a more formal. It is a private way of resolving dispute. It is more formal, and the procedures are more or less, the last week, I don't know if you are around, when Ms. Pa took us through, she gave a vivid explanation of some of the procedures, and help us to understand that it is more or less like a court session, except that some of the technicalities related to court and the rest of them are absent, so the procedure that was followed. Ordinarily, you are not supposed to come defending yourself, and then you have a lawyer. So the lawyer is supposed to take up the responsibility. He announces appearance. My lord, if you are in court, my name is so. I appear for so. Is it the applicant or the respondent or whatsoever? Yes, the representative of the company is in court in person of so. That is what they are going to do. That is the same procedure. It's just that this is a private way of resolving disputes. So technicalities, all these objections as to all those things, rules and regulations that regulates the court, they are not there. So it makes it easier and faster. So you introduce your client, introduce your case. Okay, we are before the court we are here for so and so, and we have our first witness, or we have our one and only witness in court. You call the person to come to the witness box. oh, okay, you are going to make testimony. Remember, before hearing, you must have conducted your preliminaries. You have agreed as to the filing time. You are going to file your point of claim. You are going to file your point of defense. If you have a counter claim, you must have agreed at the preliminary meeting that these are the things that you are going to be doing. So when you are coming, you have the processes of the parties. In the whole procedure process, nobody made mention of any document. Even the person that says that he was employed, he did not make reference to even his employment letter, not to even talk of correspondences or email, nothing. Everybody was just talking, and that is all. So you see, the gap, if you have made preparation, the explanation we are going to be giving is going to be more, because this mentorship is more practical oriented. It's going to have a permanent impression in your heart, such that when you have opportunity to do the proper certification training, it will be a walkover, and some of the knowledge you have already will be an advantage for you. So please, next time you ensure that you do the needful. So those procedures and things that need to be done were missing because of lack of preparation. Remember the saying that once you have not prepared for something, if you have not prepared for something, you have actually prepared to fail. That is it. So, but then we must appreciate you for your time, your effort, for even making yourself available and present, even though what you are learning is for yourself. But for you to spare time and be here is appreciated. Our own hope is that we want you, having your interest in heart, we want you to gain as much as possible for the time you have invested, so that you have something. That's why, sometimes we make rebukes, we make corrections, we say this and that, just to encourage you to. It's not only in this thing alone, any other thing you're doing, whatsoever you have put your hand to do, ensure that you do it well, so that you will be identified as someone who says, if I say I'm going to do something, I will do it. If you give yourself an impression, people have the impression that when you say you will do something, you will not do it. So next time, even when you are serious about something, people may not take you serious. So that is one of the things that you need to consider very, very well. So I believe that I have attempted your question. So let me allow Miss Pa. I believe that she has watched group 2 and group 1 make their presentations. So we have spoken a lot. So I will allow Miss Pa to highlight some of the important things that need to be addressed, and then we can now conclude. So Miss Pa.
Thank you very much, Nacha. I will just speak on two principal things. One is on the council, that should be Ephraim, and the arbitrator, and then this Ola's last question. I will say something. She's talking about a kind of how to have a standing award, or award that can stand scrutiny. So to the arbitrator, Madam Arbitrator, you did well, but you still need to improve. And again, when you're doing online arbitration, there are some rules, there are some ground rules you have to stick to. I don't know whether you were not feeling safe where you were sitting as the tribunal. I don't know what was pursuing you from left and right. You were distracted. You're not talking to the clients or your tribunal members, focusing on your screen. You kept on from time to time. I don't know what was distracting you. But if you have to be an arbitrator where you have to sit on a real arbitration in where you are being paid and doing all those kind of things, you one, you lost credit. Two, you make the parties to feel like there is some lack of what professionalism, even the credibility of the arbitrator, because you have to focus, especially when you are talking. You will not be talking and I don't know whether the parties are that way you are addressing them. So these are some of the things we are emphasizing on online arbitration or mediation, online proceedings. You have to speak to your camera. Speak to your camera because the people are watching you in front of your camera. So that's just the remark I have to give for you, the arbitrator. Take note of that. And again, your award, you need to read the contents of an award. And who are you writing your award to? Before you pick your pen and paper as an arbitrator to write an award, you have to ask yourself, who am I writing this award to? Remember, arbitration is a private process. Even court judgments are being violated by parties, of which the court has the state police. That can even go as far with bailies for enforcement. Arbitration is much more private, which your award have to be compelling. And your award is written firstly to the loser. So that because you are intending that at the end of it, the loser is the one who pays the arbitration. So if your award is not compelling to the loser that you are writing for, you have problem with enforcement, compliance. Now, Ola, to get an award that stands scrutiny or can't be set aside, first thing first, that award will only exist because there is a breach in a contract or something happened. There was either non-performance or something happened. Failure to perform, or there is a breach, or there is a non-compliance in one. So this brings us to the principles of evidence. You have to make sure that you imply the principles, the basic principles of evidence as an arbitrator. You have to know them to your fingertips. Because when that award is being challenged before the court, the judge now will be sitting in the facts and law of that matter to look at it. But there are grounds under the New York Convention 1958 for setting aside an award. So you should make sure that your award should not be set aside or challenged for the foundation, the base, which are the principles of evidence. It might be challenged for some minor things, but not for the foundational principles of evidence. You can go and read about the principles of evidence. So I think those are just the remarks. When the arbitrator was reading the award, I saw Ephraim said, when are they to comply? Yes, every award should have its starting and end date of compliance. There must be a start and an end period of compliance. But Madam Arbitrator, you did not take note of that. So read the components of an award that can stand scrutiny. And to Ephraim, the counsel, Mr. Counsel, were you fighting with your witness? Let me tell you, witnesses are sometimes very hostile. Otherwise, you find yourself like in some courts where a counsel will ask a question to witness and witness said, put it back to you. That's just what you were doing with your witness. You have to learn questioning techniques. They are open questions, they are close-ended questions. You should know what you want to hear from the witness. You will not come I saw at so many instances you wanted a yes answer from the witness, but you are asking the witness an open-ended question. The witness will say yes, but this and that. No, you don't do that. you should be able to know what you want from a witness. And witnesses are sometimes very hostile. If you're asking a question, witness, am I right to say that the HR didn't do this at this time? That is a close-ended question, and you get exactly, and before the court or the arbitrator, you are confirming a fact that has been submitted before that arbitration. That's how you steal facts from witnesses. Not when you need the witness to say yes, and you give a witness an open-ended question. Else the witness will start narrating stories. But when you want a witness to narrate a story, you open the witness with an open-ended questions. You will not come and begin to quarrel a witness over witness's name. No. Before coming, the details of the witness have been submitted. If not, you say simply, witness, can you tell this tribunal your name? It's simple. If you already have the name witness, am I correct or right to call you Mrs. this or Mr. that? Simple. And you move ahead. And by the time you are coming as a counsel, you have drafted the questions from the facts of that case that you have written. Even from their submission, the adverse party submission, you have read through, prepare your questions. So you prepare your questions and then you bring them, hoping that in case the defense or the respondent brings something different, you'll be able to adjust your questions. So I hope these tips helped you in doing your examination or cross-examination, and especially when you're doing cross-examination. Cross-examination, you hit it pungently to the point, because that's not your witness. Especially cross-witnesses are always very hostile. So you mostly use more of close-ended questions when you're doing cross-examination, because you want to confirm, you just want to confirm something, or you want to confirm what was said in your examination. And the last one again to the arbitrator. Madam Arbitrator, you write an award as the tribunal. It is the tribunal that is ruling. The tribunal rules, the tribunal rules, the tribunal awards that are not you, I. The I person that I heard you saying it is not appropriate in arbitration. It is the tribunal. The tribunal reads that, the tribunal holds that, the tribunal rules that, or the tribunal awards that. So that said and done, those are the little comments I have for today's session. But you people should take this session we are doing with you guys very seriously. From the beginning, I was wondering what was happening. I want to say, if you have team leaders, make sure you do your work to organize your members before each session. We will not come and spend like 20 minutes of our time trying to put things in order. Please, you people are becoming future practitioners. The Settlement House has an event tomorrow. You people should attend and join. Make sure you learn from professionals. Make sure you take up certification courses. It's very, very important. Thank you all and good evening.
Thank you very much, Ms. Fa, for that wonderful contribution. I haven't said so. So, group one, as I said before, your contribution was more or less, your presentation was more or less like a mediation session. And that was so because you did not, I cannot see anybody again. I don't know if
yes, sir.
Okay, thank you. So first of all, you need to know that the arbitration session is it's more or less like a court. So you check the procedures in court. When you have had your preliminary meeting and you have agreed on the things that needs to be done, and then you came for hearing, you have the parties, their councils. Now, the first session, it was the councils that presented the matter. I was wondering, are the councils to the parties themselves? Can a council testify on behalf of the party? You did not tell us that
Sorry,
it
sir.
is.
Sorry, sir. Hold on. Sorry, sir. Our group we are well complete. We are only three that presented. That's why we didn't have representative of the either the respondent or the claimant. That's why we only
Yes,
use three of us and we are available. So sorry.
yes. What you are supposed to do is, I don't think you are supposed to have counsel when counsel representing the parties having to testify. It is not a document only arbitration that counsels can now present and make arguments. You are expecting to give evidence, you know. So if you are giving evidence, counsel cannot go and sit in the witness box and begin to give evidence. And so when a party is called, the registrar will go and affirm or swear him to tell the truth, to say the facts as it is stated. Because when you make when you present your
All right,
documents,
sir. It's well noted, sir. It's noted, sir.
when you present your processes before the arbitrator, you have your points of claim, the documents that are attached, you have witness deposition, you know, the person that is going to testify, the things that are going to be done, and all of those things will be there, isn't it? So when you come, just like you do in court, just like you do in the court, it's the same. You adopt your process before the arbitrator. If there are documents that you need to tender, you draw the attention of the arbitrator at paragraph so and so. You made mention of your letter of employment. Say yes, this is it. Okay, all the documents are there. You have already forwarded it. Everybody has it. So for the purpose of emphasis, all the documents have been the arbitrator can still admit all of them. By the way, they already have it. It is not a strict, it's not the rules of evidence, as you know, does not apply. The Evidence Act does not apply to arbitration proceedings. So you haven't done all of those things. When you finish, you tender your documents, your papers, everything is in, and then you give opportunity for the counsel on the other side to ask questions. Those questions will be cross-examination questions. This is an evidence in chief. You have set your own. You may seem to be right and correct and everything until you have opportunity to ask questions. So you can see it in the second group while they are presenting. You can see the importance of cross-examination. So because party A did this and that, you have promised you are going to frustrate his life. That is what you have done, isn't it? And then the council was like, the party was like, no, that no, I did not do all of those kind of things, So you can see the beauty of asking questions. Okay, you are supposed to get back to um the employee, Mr. Musa. Did you do so? Say yes, I did so. Okay, do you have evidence before this tribunal to show that you have done so? Yes, no. Just highlight the important things. If you ask the question like the way he was asking, you now allow the person to tell a story. He will tell the story and go and begin to correct the things that he has said before.
Okay, sorry. I think Mr. Niacham's network. Okay, sir, are you with us now, sir?
Okay, so the things, if you ask open-ended question during cross-examination, you give opportunity for the party to go and begin to make explanations of the things that you did not ask. So you say, did you employ this Mr. Musa in your company? Yes. According to your letter of employment, you agreed to pay them 20,000 naira per month. Yes. He was supposed to resume on so time. Yes. There was COVID-19 during that period. Say yes. There was an instruction that you should get back to him so that he can work remotely. Yes. You did not get back to him. Yes, no. You ask the question, okay, for the period of 6 months, according to the terms of employment, he was employed with you. Yes. You have not paid him for the period of 6 months since he was employed. Yes. You are establishing your matter, you are making it very bad. If you give the opportunity, say, okay, why didn't you write the letter? Okay, cancel to the employer, the representative of the company is here. Or explain according to the arbitrator. Or come on and explain. Those kind of things. So that's the cross-examination. You cross-examine. Then when you are done with the person who brought his claim, then the respondent may even have a counterclaim. All of it, you are going to speak to it. The evidence is after you have your processes before the court, you have adopted it. Once you have it, you just adopt it. The facts are already there. If there are documents or there are particular paragraphs you need the arbitrator to take note, draw the arbitrator's attention to those paragraphs, and then identify the things you want there. Then at the end of it, the lawyer on the other side will also ask questions. So you are the lawyer representing the company. Okay, according to your letter of employment, you need to work before you are paid. Yes. You have not worked for this company even for a day. Yes. So, you are already laying the foundation for your this thing. So after when you have not heard from the HR, as you said, you have not reached out to the HR herself to find out why you have not heard from her. Yes, I have not reached out to her. So you ask based on the facts of your case and information that will, even the issue that Olua was asking the other time. She was saying that the name on the process, you say, okay, in the entire process, the HR is not Mrs. So. You just ask the question, let the person clarify it. That's your cross-examination. At the end of it, you see, in as much as a private way of resolving disputes, when you have laws that regulate, you have decided cases and the rest of it, you will cite them. When you finish the hearing procedure, everybody has testified. Then you now come to the conclusion. You must have agreed during your session, your preliminary meeting, that parties will have like 5 minutes or 10 minutes to do a final submission, a closing address. It could be written, it could be oral. If you agreed oral, 5 minutes, 10 minutes. So let the counsel to the respondent address the court first, the tribunal first. You stand up, you have to identify the important things. Okay, our matter before this tribunal is that my client has been employed, he has resigned his employment, he has come, there was COVID-19, he was expecting to work remotely, he has not. What are the facts? What are the documents that support what you are saying? What are the laws that support what you are saying? You identify them. I have 2 issues to identify. Was he an employee of the company? Yes, he was an employee by virtue of that. Okay, having been employed, Have they assigned responsibility to him or not? Oh, they have not assigned responsibility. What will be the position? So you argue based on his letter of employment, which is Exhibit A, and this, and that, he was employed on so time. Based on this and this and this, these are the terms of his employment. This is the salary that you're supposed to be paid, and he has not been paid. The law says this. In the case of so and so, there was an employee and employer relationship where the court says that once you are employed and you have finished your documentation, you are entitled to your salary. Cite the case and let the arbitrator go through it and see it for himself. It supports your cause. That's your final address. You are identifying important issues that you want the arbitrator to put in mind while writing his award. And when the respondent finish, the complainant, will also make his own final address. He may decide to make his own final address, and then if he cites law and whatsoever, if you have something to add or you want to respond on points of law to some of the things that were stated, you draw the court by your own. You present your own, identify issues you want the arbitrator to consider, cite the evidence and the documents. Okay, on paragraph this on their statement of defense, it admitted our claim, it supports our claim, this is what the law says, this is his letter of employment, these are the documents, these are the letters he has written to the company, this is the email that they exchange. All of those things are stated there, and because of this, we believe that our client is the award should be in favor of our client due to this and this reason. If you have any law that supports your cause and whatsoever, you cite it, and then you close your this thing. When you close it, they adjourn the matter. When you adjourn the process for an award to be published, you clarify whether they have paid all your fees and everything is set. Registrar has confirmed everything is okay. Then you say within 1 month or 2 months or within 2 weeks, we are going to publish the award. You don't read out the award to them in public or whatsoever. Publishing the award simply means that you have sent the award to the parties. If they don't have outstanding, there is no any reason why the thing should not be published. You publish the award by sending it to the parties concerned. Simple. That brings it. So then brings it to an end. Then somebody say even upon appeal, it will be upheld. You don't appeal arbitration award. You don't appeal. According to the new law, AMA 2023, there are grounds you can apply to the court to set aside an award, but you cannot apply to you cannot appeal against an award. You can't appeal. You can have, if you have grounds, even the grounds are also limited. You must show maybe the arbitrator misconducts himself, he was impartial, he was this and that. All of those things you have to show, before you do that. So you must take note of that. A witness who is testifying can testify on oath, administer the oath. The registrar.
Hello, Mr. Nyacham, can you hear us? Please, can someone confirm that it's only me that cannot hear? If I'm the only one that can hear Mr. Nyacham, that cannot hear him.
I also can't hear him.
Okay, I think his network is breaking. So please let's exercise a little patience. I'm sure he will be joining us shortly.
Should administer the oath to the person.
Hello, sir. Can you hear us now, sir?
Yes. So, sorry. So that is it. You Now, when you are given an award, the important thing you need to note is that an award should carry a summary of the facts before the tribunal, and then your award, and then the reason why you are giving the award, because the award may go against a party. So you give reason why you decided your award against a particular person and in favor of a particular person. That is very, very important. Now, the session, when you are commencing, my name is Nanchang Nangwang. I am the Executive Director of Settlement House ADR Training Institute. I am a mediator, I'm an arbitrator, I am this and this. You introduce yourself. For the purpose of this arbitration session, you can address me as Mr. Arbitrator. You can address me as Mr. Nanchang. Okay, you go to the parties. Who do we have here? The lawyer will introduce himself. Okay, my name is N. Nanchang, ESQ. I announce appearance for the applicant or the respondents before, and this thing say before you also we have a representative of the company in person also. So if the person will introduce himself, for the purpose of these proceedings, you address me as counsel to so. You address me. So even if they did not do so, the arbitrator should guide them. How do we address you in the course of this? So it's a relaxed session. It's not formal. You don't be afraid of anything. So, but the procedures, you follow them so that you know how to address somebody. Because if you address him the way he doesn't want to be addressed, it may end up affecting the process one way or the other. And the facts you are supposed to get from the parties that will help you decide your matter favorably, more so that you are going to be given an award, a decision that is going to be binding on the parties. So you don't need to warn them and that this thing, even if you go on appeal, is going to be upheld. No, you don't need to do. Your own is that do your work well. So you just ensure that some of the things you need to take into consideration in writing your award, you do it. As simple as that. Do it and ensure that you conclude it, and do it in such a way that even when they appeal against it, it will not affect what you are doing. It will not affect the award you have given. So that is the important thing you need to take note of. So having said so, I think we have covered some of the things that we need to cover. So Mr. Dennis, I don't know, over to you. First, I think for those who are here and who want to take advantage of the training, that's the certification training, JIIPCC and Shati has made a very considerable offer for those who are participants. So if you know you want to take advantage of that, you can write your name and your phone number and drop it in the group there, so that we'll know that you are interested. Then Mr. Dennis can we'll see how we can pursue it. So over to you, Mr. Dennis, for further
All right,
explanation.
thank you very much, sir, for that. Thank you so much, Mr. Nyacham, and thank you to Ms. Mispa for giving clarification and guidance to our mentees as regards the simulation that they carried out. So, like Mr. Nyacham rightfully said, um, the Settlement House Training Institute has put out an offer for our mentees for certifications, for more certifications in the lines of ADR, right? So if you're interested, please, like Mr. Nelson have already said, put down your contact details on the group, and then we'll pick it up from there and try as much as possible to get back to you. So please, the offer that has been made by the Settlement House ADR to do this is relatively cost effective, right? If you take into consideration if you were to pay in at the amount or at the rate you are supposed to pay for the certification, it's actually more. So please, we would like for our mentees to take advantage of that. And please do not forget, like Mr. Nyasham also said, tomorrow there's a free training, right? That we encourage all of you to be a part of. If you haven't registered, please do well to register for the session tomorrow. And also, just lastly to state before we close the session, remember, I would like our mentees to remember that on Saturday we'll be having three combined sessions, one by 11 a.m., then by 2 p.m., and lastly by 5 p.m. Um, Attendance is mandatory for all mentees, right? You are supposed to be in all three sessions. You are not supposed to select one and leave the other two, right? You are supposed to be in all three. So we encourage all the mentees to try as much as possible to clear out their schedules to be in those three sessions. I trust that they will be very helpful and they will be part of the accumulation to the whole mentorship program as a whole, as you have experienced under the ADR under the ADR course. And I think with this, we've come to the end of today's session. Thank you to our mentors once again for helping us run through the simulation. I look forward to further collaboration and further participation for our mentees in taking up the offers that we have put together with the Settlement House ADR Training Institute for you. So please do what you can to take advantage of it. Develop yourself, build yourself, and we'll see you at the very top. Good night, everyone, and once again to our Muslim compatriots in that sense, right? I wish you all a happy Salah celebration. Goodbye, everyone, and good night.
Good night. Thank you.
Thank you. Good night.
Don't
Good
forget
night.
to put down your name quickly if you know you want to be
Good
included
night, sir.
in the if you want to be included in the training, the certification training. Make sure you put down your name on the group, please.